Good afternoon, everyone. This is Attorney Reyes. This afternoon, we are going to discuss about criminal procedure. So let me share my screen with you. Okay, criminal procedure. First, let us define what criminal procedure is. Now, criminal procedure is the method prescribed by law for the apprehension and prosecution of persons accused of any criminal offense, and for their punishment in case of conviction. So when you say criminal procedure, basically this is the manner or method by which the violation of the law amounting to a crime is prosecuted in court. Now, it provides for the methodology or the process of prosecution up to conviction or acquittal of the accused. And then, in case of conviction, the court will have to impose penalty or punishment. Now, when you say criminal procedure, this is remedial in nature. When you say remedial, it provides how the act is to be punished, and it provides a method by which a person accused of a crime is arrested, tried, and punished. So aside from the fact that criminal procedure provides for the methodology on how trial is conducted in court, the rules on criminal procedure likewise provide for the methodology by which a person accused of a crime is arrested, tried, and punished. Okay? Now, what is criminal jurisdiction? When you say criminal jurisdiction, this pertains to the authority of the court to hear and try a particular offense and impose the punishment for it. So when you say criminal jurisdiction, this is the power of the court to hear and try a case, not a criminal case or offense, and impose the punishment for it. Okay. Now, what are the elements of criminal jurisdiction? Number one, penalty. Now, the jurisdiction of a court in a criminal case is determined by the penalty imposable and not by the penalty ultimately imposed. Now, when you say penalty attached, the jurisdiction of a court, when you say jurisdiction, this is the power of the court to hear and try cases. Now, when do you know or where, now, how do you know in which court to file your complaint? For example, there is a violation of Republic Act 9165, the Dangerous Drugs Act. How do you know that this complaint, this criminal offense, is to be filed in the lower court or in the first level court or in the second level court? Now, the jurisdiction is determined by the penalty imposable. When you say penalty imposable, this is the range of penalty provided by law that can be imposed against an offender. Now, when you say that that jurisdiction is pegged on penalty, when you say penalty, that penalty pertains to the penalty imposable by law and not the actual penalty that is ultimately imposed by court. What do we mean by this? Now, sometimes the law will provide for the highest penalty or within that range. For example, if the penalty imposable is reclusion perpetua, okay, which is imprisonment for 20 years, 1 day to 40 years, the court can impose a lower penalty for that offense if, for example, there are attendant mitigating circumstances under the revised penal code. Now, if there are circumstances which mitigates the penalty, the court can impose a lower penalty. Now, the question is, what will determine the jurisdiction of the court? Is it the penalty provided by law or the penalty actually imposed by court? The answer is the penalty imposable or provided for by law and not the actual penalty. That is what you mean by the statement that the jurisdiction of the court in criminal cases is determined by the penalty imposable, which means that penalty which is provided for by law and not the penalty which is actually or ultimately imposed by the court. Now, what is the second element of criminal jurisdiction? The nature of offense charge. Now, you know, you learned in your study of criminal law that there is no crime unless there is a law punishing it. Well, that is an elementary principle on criminal law. That an act, no matter how morally wrong, no, will not amount to a crime unless there is a law which defines such act as a crime. So the nature of the offense charge. Now you will recall that under the civil code there are several sources of obligation. One of them is a crime or delict. Unless an act, again, is considered by law as a crime, then it will not be considered as a crime. The nature of offense must be considered by a penal law to be a crime or offense before it will fall under the criminal jurisdiction of the court. Now, number three element or the third element of criminal jurisdiction is territoriality. Territorial jurisdiction over the place of the commission of the crime. Now, what do we mean when we say territorial jurisdiction? You know for a fact, class, that in criminal cases, venue is jurisdictional. What do you mean by venue is jurisdictional? Now, in a criminal case, the complaint or the information, not the criminal charge or indictment, can only be filed in the place where the crime was committed or in any of the places where any of the essential ingredients of the crime have been committed. No? Kung saan nangyari ang krimen, you can only file the complaint in that place. That is what you mean by the territorial jurisdiction over the place of the commission of the crime. For example, class, in the prosecution of Batas Pambansa bilang 22 or BP 22, the bouncing checks law, where can you file a complaint for BP 22? The answer is you look in the elements of the offense. What are the elements of BP 22 or bouncing checks? The issuance of a check, no, of a worthless check, and that check was subsequently dishonored by the drawee bank for insufficient funds or closed account. Now, those are the elements or the gravamen, so to speak, of the crime of BP 22. Now, question, where do you file a complaint, a criminal indictment for BP 22? You have to check where the issuer, no, of the check or the maker of the check has issued the check. Or for example, the check after issuance was presented in another place. You can also file BP 22 in that place where the check was presented for encashment or deposit. So in any of these places, you can institute a criminal offense because as the essential ingredients of the crime have transpired in those places. That is what we mean by territoriality or territorial jurisdiction over the place of the commission of the crime, which again means that a criminal complaint can only be filed in the place where the crime was committed or in other places where any of the essential ingredients of the crime have been committed. Territoriality, it pertains to the place. Okay. Now, elements of criminal jurisdiction. The absence of any of these elements may be challenged by an accused at any stage of the proceedings in the court below or on appeal. Failing to comply with any one of them pertaining to the essential elements, no, the resulting judgment is a total nullity or void. Now, in case that a court would not have all the elements of criminal jurisdiction, the accused can challenge such absence of jurisdiction. No? Okay. Now, when can the accused raise as an issue the absence of the elements of criminal jurisdiction? According to the law, it can be raised by the accused at any stage of the proceedings in the court below, meaning the trial court, and or on appeal. So either in the lower court and even on appeal, the accused is at liberty to challenge the jurisdiction of the court in case any of the essential essential elements of criminal jurisdiction is lacking. Then the accused can always and always challenge this as a matter of right. Okay. Now let us compare jurisdiction over the subject matter and jurisdiction over the person of the accused. When you say jurisdiction over the subject matter, this pertains from the authority of the court, which is derived from law. Jurisdiction over the subject matter is derived or it is based on law. It can never be acquired solely by consent of the accused. Class, when you see jurisdiction over the subject matter, ang tanong dyan, meron bang kapangyarihan ang hukumang litisin ang kasong ito? Now, pag tinanong tayo, meron bang kapangyarihan ang husgadong itong litisin ang kasong ito? Where do you look at? You look from the provision of the law. Now, what do you check with the law? The law will tell you that this offense can be filed in the proper regional trial court or municipal trial court as the case may be. But in case the law fails to specify which court will have jurisdiction over the subject matter of the offense, then you look at the penalty imposable. If the penalty imposable is more than 6 years, meaning 6 years and 1 day of imprisonment, then you go file the complaint in the regional trial court. In the regional trial court. Now, if the offense will have an imprisonment of 6 years or less, then you go file the criminal complaint before the first level courts or the municipal trial court or the metropolitan trial courts. Because jurisdiction, class, the authority of the court to hear and try the offense is derived from law. It is the law which will what? Grant jurisdiction or authority over the court. Okay. Now, on the other hand, jurisdiction over the person of the accused may be acquired by the court by consent or by waiver of objections. Now, class, yung authority of the court over the person of the accused is acquired by arrest. If a person is arrested, he is placed in the custody of the law. And when he is placed in the custody of the law, the police officers will have to what? Report to the honorable court the fact of arrest of the accused. And so when a person is arrested, the court acquires jurisdiction over his person. Okay? The court acquires jurisdiction over the person. So there are only two modes by which jurisdiction over the person of the accused is acquired. Number one, in case of arrest. Number two, in case of voluntary surrender. Kaya class, di ba? When you go on your practice, no, when you're a full-fledged policeman, sometimes a warrant of arrest is issued. No, so that will be assigned to the warrant officer. The warrant officer is responsible to bring into the custody of the law the person of the accused. Now, in case that the accused learns the issuance of a warrant of arrest, the accused can very well post bail. By posting bail or tinatawag nating piyansa, okay, piyansa, the accused will appear in the court and what? Voluntarily surrender his person to the judge or the court. No, the accused can post bail in before the judge who issued the warrant of arrest or in any other places as the case may be. So that is the difference between jurisdiction over the subject matter and jurisdiction over the person of the accused. Again, class, only the law can vest jurisdiction over the subject matter to a court. Batas lang ang magtatakda kung saan ang kapangyarihan ng husgado. Sa kabilang panig, jurisdiction over the person of the accused is acquired by two modes. One, arrest. Second, voluntary surrender. Okay. What is the second distinction between jurisdiction over the subject matter and jurisdiction over the person of the accused? In jurisdiction over the subject matter, objection that the court has no jurisdiction over the subject matter may be made at any stage of the proceeding, and the right to make such objection is never waived. Now, class, dahil batas ang nagtatakda ng kapangyarihan ng husgado, kahit hindi mo yan questionin sa ilalim o sa lower court, at for the first time on appeal, umakyat ka, natalo ka, nag-apila ka, question, can you still question the jurisdiction of the court over the subject matter? Answer, yes, yes, yes. Because jurisdiction over the subject matter is determined by, is derived from the, or derived from law. Batas ang nagtatakda. Even if you fail to raise that question early on during trial, you are still not barred. The accused is still not barred to make such objection. Ibig sabihin, kahit hindi niya nabanggit sa ilalim, pag nag-apila siya at umakyat siya, maaari niya pa rin niyang gamitin as one of the errors. The accused can still raise this as a matter of law, as a matter of legal right. Now, on the other hand, jurisdiction over the person. Now, if the accused have some questions or objections over his jurisdiction, then it must be timely filed. Meron diyang timeliness. Kung ang jurisdiction over the subject matter can be raised even on appeal, jurisdiction over the person of the accused must be timely interposed. Otherwise, if the accused did not timely interpose that objection is deemed waived. No, it is deemed waived. If the accused fails to make his objection on time, he will be deemed to have waived such objection over the jurisdiction of the court over the person of the accused. Okay? Okay. Now, third distinction. Jurisdiction over the subject matter is determined upon the allegations made in the complaint or the information in a criminal case, irrespective of whether the plaintiff is entitled or not to recover upon the claim asserted therein, a matter resolved only after and as a result of the trial. Now, class, what will determine jurisdiction over the subject matter are the allegations in the complaint or the information. Okay? When you are already a full-fledged policeman, you attend the court hearing, di ba meron tinatawag na sakdal? Sa Tagalog, sakdal. Ano ba yung sakdal? The information. The information will contain the act or acts or omissions which are accused of the accused. Kung ano ang ibinibintang sa kanya, yan ang laman ng demanda, hindi pala sakdal, demanda, no? The information will contain the law that he violated and the acts or omissions constituting the crime. For example, if the crime charge involves violation of the Dangerous Drugs Act, ang nilalagay dyan that the accused on or about blah 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 have illegally and feloniously sold a plastic sachet containing 0.1 grams which is suspected to be a methamphetamine, hydrochloride, etc., etc. That document code information will determine the jurisdiction of the court. No? Jurisdiction as based on the information. Now, jurisdiction over the person of the accused is acquired again, as I've told you, by voluntary appearance or what? Arrest by or on his person. So dalawa lang ang mode. Arrests or voluntary appearance. Okay. Now, what are the requisites for the exercise of criminal jurisdiction? Jurisdiction over the subject matter to which the proceeding in question belongs. Okay? Number 2, jurisdiction over the territory. I've discussed it with you that the criminal complaint or indictment can only be filed in the court which has territorial jurisdiction over the place where the crime was committed or where any of its essential ingredients took place. No? Kasi class, di ba? For example, may mga crimes na nako-commit in transit, for example, in a train or a bus, nagkaroon ng hold up, 'di ba, ng robbery. No, you can file the information or the indictment from the point of transit up to its last point. Lahat ng lugar na dinaanan niyan, you can file the criminal complaint because the elements or essential ingredients of the crime took place within those places. So you can choose which place you can file your complaint as long as the essential ingredients of the crime took place therein. Okay. And number 3, jurisdiction over the person of the accused. Now, the court will not acquire jurisdiction over the person of the accused in case there is no arrest or there is no voluntary surrender. But class, you have to take note that only a valid arrest will vest the court jurisdiction over the person of the accused. What does that mean? That means that if the arrest made was in violation of the Constitution or the arrest made is unlawful or illegal, then the court will not acquire jurisdiction over the person of the accused. Illegal ang arrest, walang kapangyarihan ang husgado sa akusado. Ha? Tandaan niyan. Only a valid arrest can vest the court jurisdiction over the person of the accused. Okay? Now, class. One of the requisites for the exercise of criminal jurisdiction is that the court must acquire jurisdiction over the subject matter of the offense. Now, class. As a general rule, as sabi natin kanina, if the accused have some objections over the jurisdiction of the court over the subject matter, he can raise that where? On the lower court during trial or even on appeal. But that is only the general rule. An exception to that is the case of Tiham versus Ibonghanoy. No, this case would give you the exception from the general rule. Now, class, if a party raising the question of jurisdiction is guilty of estoppel or laches, anong ibig sabihin ng estoppel, class, or laches? Ibig sabihin niyan, class, in this case of Tiham versus Ibonghanoy, what happened was the party raising question on jurisdiction have actively participated during trial. Huh? He actively participated during trial. He sought relief from the court. And then, the only time that he raised this question of jurisdiction is on appeal after he had received an adverse judgment. Sabi ng Korte Suprema, in that case, merong tinatawag na estoppel. You are now prevented. You are now barred from raising the question of jurisdiction because you have actively participated during trial. You have sought affirmative relief from the court, and so you are guilty of estoppel. You cannot, ang ibig sabihin ng estoppel class, ganito. You cannot question the jurisdiction of the court after you have invoked it by seeking affirmative relief. Kasi hiningi mo na ang affirmative relief from the court, humingi ka sa ilalim, sa baba. Tapos sasabihin mo later on, wala pala siyang jurisdiction. So estopped ka na. You are now barred from taking inconsistent position. Okay? So that is the exception. Okay. Now, what are the tests to determine jurisdiction of the court in criminal cases? Okay. Number 1, the geographical limits of its territory. Di ba, class? Sa ating mga husgado, may tayong Regional Trial Court Branch 114, Regional Trial Court Branch 152 or 154 in Binyan, for example, or in Pasay. No? That regional trial court have geographical limits. Ibig sabihin hanggang Pasay lang siya. No? Lahat ng offenses committed in Pasay can only be filed before the regional trial court of Pasay City or in Binyan City, for example. So the courts have geographical limits of its territory. No, yan ang sa trial courts. But of course, sa Court of Appeals and Supreme Court, for the entire country, no? Ang may geographical limits lang class yung mga trial courts. Now, second, determined by the allegations in the complaint. We have settled this already. Determined by the nature of the offense. We have said this already. Determined by the law enforced at the time of the institution of the criminal action and not at the time of its commission. Once vested, it cannot be withdrawn. Okay. Okay. Now, we will skip this one because I don't think that this is relevant for your purpose. Injunction to restrain criminal prosecution class. This is not, this is more for the lawyers, not for the policeman. Okay. Now, let us go to Rule 110 or 110 of the Rules of Court. This is where criminal procedure starts. Prosecution of offenses. Yan. Simulan na tayo. Now, what is a criminal action? When you say criminal action, what do we mean by this? A criminal action is one by which the state prosecutes a person for an act or omission punishable by law. A criminal action is the act of the government or the state in prosecuting a person for the commission of an offense or a crime. If a crime has been committed, then the state will institute a complaint in court, a criminal complaint, and that criminal complaint is called criminal action. Now, what is a criminal action? It is one by which the state prosecutes a person for an act or omission punishable by law. Now, how do you institute criminal actions? When you say institute, ano bang ibig sabihin natin yan? How do you go file a criminal action? Papaano ka magsasampa ng reklamong kriminal? Yan. Institution of criminal action. Criminal actions are instituted by, number 1, by filing a complaint with the proper officer for the purpose of conducting the requisite preliminary investigation for offenses where a preliminary investigation is required. Number 2, for all other offenses by filing a complaint or information directly with the MTC or MCTC or the complaint with the office of the prosecutor. Now, class, ang tanong, how do you institute criminal actions? Papaano ka magsasampa ng reklamong kriminal? Una, you can file a complaint or complaint affidavit, ang tawag natin dyan, complaint affidavit o demanda o reklamo. Kanino? Sa piskalya na tinatawag. No, dati-dati ang tawag dyan, piskalya. Ngayon ang tawag na prosecutor. No? The office of the provincial prosecutor or the office of the city prosecutor. Yan. Diyan if na-file ang criminal complaint. Now, paano mo malalaman? How do you know if you will file it before the office of the provincial prosecutor or the city prosecutor? Madali lang yan, class. Pag walang city prosecutor, doon ka mag-file sa provincial prosecutor. Kasi hindi lahat ng syudad ay merong city prosecutor, no? So kung city yan, most probably meron niyang city prosecutor. Now, if in the absence of the OCC or OCP, you file it before the OPP or Office of the Provincial Prosecutor. Now, if you go file your complaint before the Office of the Prosecutor, be it a city or a provincial prosecutor, then you have instituted a criminal action. That means that you have filed your criminal complaint. Now, for other offenses, fina-file na yan, diretso ka na sa husgado. Hindi ka na dadaan sa piskalya. No? Diretso ka na sa MTC, sa first level court. In other words, hindi na yan dadaan sa prosecutor o fiscal. No? Diretso ka na sa court. Now, question. How do you know that a complaint can be directly filed in the first level court, or if you need it to be filed, or if it needs to be filed before the office of the city prosecutor or provincial prosecutor? Madali lang, class. Madali lang. Para malaman mo kung ifa-file mo diretso sa husgado o sa prosecutor o piskalya muna, tignan mo kung kailangan ng preliminary investigation. No? Pag kailangan ng preliminary investigation, doon mo yan ifa-file sa city prosecutor or provincial prosecutor. Now, may mga offenses. There are offenses which do not need a preliminary investigation. Hindi nila kailangan ng preliminary investigation. Pag hindi kailangan ng preliminary investigation, hindi mo na idadaan sa piskalya, diretso ka na sa husgado. No? Again, how do you institute criminal action? You file it with the office of the prosecutor. Or if the offense does not require preliminary investigation, you go straight to the court, the MTC or MCTC. No? Now, when do we know that a complaint needs a preliminary investigation? O, diba? It begs the question. Kanina, sabi mo, ifa-file natin sa piskalya kung kailangan ng preliminary investigation. Tapos kung hindi kailangan, pwede ka nang dumiretso sa court. It begs the question, paano mo malalaman kung kailangan ng preliminary investigation o hindi? We will answer that question later on. Okay? Now, for Metro Manila and other chartered cities, the complaint shall be filed with the prosecutor regardless of the imposable penalty. While cases falling within the jurisdiction of the RTC are always commenced by information filed by the prosecutor. Class, pag naghabla ka sa RTC, lagi yan merong preliminary investigation. Lagi kang dadaan sa piskalya. Ang pinagtatalunan na lamang ay yung sa MTC or the first level court. Yung ibang offenses within the jurisdiction of the MTC, those are covered by the rules requiring preliminary investigation while others are not. No? Okay. Now, direct filing of a complaint with the RTC or MTC and other chartered cities. Okay? Second, there is no direct filing of information or complaint with the RTC. Kasi class, lahat ng offenses within the jurisdiction of the RTC require preliminary investigation. So dadaan ka sa piskalya pag RTC. Pag MTC, depende. No? There is likewise no direct filing with the METC. Class, pag nakita yung METC, ibig sabihin yan, or METC, ang ibig sabihin yan, Metropolitan Trial Court. Kasi yung Municipal Trial Court, para yun sa mga municipalities. Kapag cities ang tawag natin dyan, Metropolitan Trial Court, not Municipal Trial Court, or MTC. Ang tawag natin dyan, METC, or METC. Now, sa Metro Manila, class, lahat ng first level courts dyan would require what? preliminary investigation, and therefore you should file your complaint before the office of the city prosecutor. Okay? Now, as a rule, aside from Metro Manila, lahat ng chartered cities, when you say chartered cities, ito yung mga municipality na nag-convert na into a city, meron silang sariling charter through a statutory law or Republic Act. No? As a rule, the complaint shall be filed with the office of the prosecutor unless otherwise provided by their charters. In case of conflict between the city charter and the provision of the rules of court, then the charter will prevail. Okay? Now, what is the effect if you have instituted a criminal action? Pag nakapagsampa ka na ng kaso, class, ano magiging effect niyan? As a general rule, the institution of a criminal action will interrupt the running of the prescriptive period or the period of prescription of the offense charge. Class, di ba alam niyo yung prescription? Ang ibig sabihin ng prescription, you can only file a complaint within a certain period. Pag nag-lapse na yung period na yon, hindi na siya pwedeng i-file. Ang tawag doon, nag-prescribe na. No? Prescription. Now, kasi yung mga offense, tumatakbo ang oras tapos hindi mo pa isinasampa sa piskalya o sa husgado, no? Depende sa penalty. Now, pag naisampa mo na yung reklamo mong kriminal, mai-interrupt na. Hihinto ang pagtakbo ng prescription or period of prescription. Now, the filing of a criminal complaint, be it before the city prosecutor, be it before the courts, will interrupt the running of the prescriptive period of the offense charge. Okay? There are exceptions. The prescriptive period of violations of special laws and municipal ordinances. Diba, class? Minsan, may mga syudad na bawal kang lumabas ng walang t-shirt. Bawal kayo magdoble kara. Marami na huhuling ganyan, di ba? Especially sa Metro Manila, marami silang mga ordinance. Now, ang violation ng ordinance being a species of law is also criminal in nature. Pwede kang makulong. For example, violation of curfew. Basta may ordinansa, pwede kang makulong. Ibig sabihin, isa siyang krimen. No? Now, when it comes to the prescriptive periods of violations of special laws and municipal ordinances, it can only be interrupted by the filing of the complaint or information in court. Yan ang exception. Kapag violation ng special penal law or ng ordinansa, kailangan ma-file mo na yan sa husgado para ma-interrupt ang running ng prescriptive period. That means that the prescriptive period will not be told, will not be interrupted if the complaint have not reached the court. Only the filing of the complaint or information in court will interrupt the running of the prescriptive period, unlike under the general rule. So pag ang na-violate mo, class, is the revised penal code, pag na-file mo yan sa prosecutor, ma-interrupt na ang running ng prescriptive period, but not in case of a municipal ordinance or a special law. Again, what will toll, what will interrupt the running of the prescriptive period is the filing of the complaint or information in court, bar none. Okay. Now, the filing of a complaint with the prosecutor or the proper officer for purposes of conducting preliminary investigation will not interrupt the prescriptive period. That is in accordance with the case of Saldivia versus Reyes. Okay. Now, prescriptive periods of cases falling under the authority of the lupon. Now, class, meron tayong tinatawag na katarungang pambarangay. Diba? Hindi lahat ng reklamo sa piskalya o sa husgado ay maaaring diretso ng isampa. Kailangan dumaan ka muna sa barangay. Yung tinatawag na lupong tagapamayapa. Diba? Tagalog, no? Lupong tagapamayapa. No? Doon sa ating katarungang pambarangay. No? The prescriptive period shall be suspended from the time of the filing of complaint with the punong barangay, which suspension shall not exceed 60 days. Tanong, pag ang reklamo mo ay dinaan mo sa barangay, that will also suspend, interrupt, toll the running of the prescriptive period. But it shall not exceed 60 days. Ibig sabihin, from the time that you have filed your complaint before the barangay, you count 60 days. Matutol, mai-interrupt. The period of prescription will get suspended, no, in the meantime. Okay? The prescriptive period shall resume upon receipt of the certificate of repudiation or certificate of certificate of file action. Yun yung endorsement na tinatawag sa barangay. Kailangan magreklamo ka muna sa barangay. Pag hindi kayo nagkasundo doon or hindi siya sumipot ng 3 beses, bibigyan ka ng barangay ng endorsement or certificate to file action. That is in accordance with Section 410C of the Local Government Code. Okay. Now, class, hindi lahat ng krimen, hindi lahat ng offenses can be prosecuted de officio. What do you mean prosecuted de officio? Ano sabihin niyan? De officio. No? There are crimes or offenses which cannot be prosecuted except on a complaint filed by the offended party, or if the offended party is a minor, by the parents, grandparents, or the guardian. These are also known as private crimes. Meron palang private crimes. Akala ko ba yung krimen is a violation of the peace between the state and the people, or between the people and the accused? Yes, there is such a thing as a private crime. Actually, isang public crime or just a crime and a private crime. Now, class, under our legal system or our penal legal system, there are certain offenses which can only be filed by the private offended party or the private complainant. Iba-iba kasi yan eh. Pag public crime, walang private offended party. Usually. For example, class, yung violation ng 9165, Dangerous Drugs Act. Meron ba diyang private offended party? Wala. Kasi wala naman diyang danyos. Wala naman diyang civil liability to begin with. No? Meron namang mga krimen na merong, although it is a public crime, merong private offended party. For example, the crime of theft, diba? Or robbery. The private offended party is the owner of the property which was unlawfully taken from another. Diba? Siya ang private offended party. Now, class, when you say private crime, hindi siya pwedeng isampa sa husgado nang walang partisipasyon ng private offended party. Kailangan kung sino ang private offended party, siya lang ang may karapatan na magsampa ng demanda. Tanong, pwede bang isampa ng police on behalf of the private offended party? Answer, no, no, no. In private crimes, only the private offended party can institute or can file the criminal complaint. Ay tatawag nating offenses or crimes that cannot be prosecuted de officio na tinatawag. Now, as a general rule, all criminal actions initiated by the complaint or information are filed by the prosecutor. No? Yan ang general rule. Exception to the general rule is are private crimes. Yun yung tinatawag natin kanina. Now, ano-ano ba, class? Yung mga offenses under our penal legal system that are considered as private crimes and therefore only the private offended party can file them or can institute them. Number 1, adultery and concubinage. Ano may adultery, class? This is the offense, the crime committed by the wife. In case the wife will have sexual intercourse with a man other than her husband. That is the crime of adultery. The crime of concubinage, on the other hand, is the crime committed by the husband. No, in case, for example, He have maintained a mistress in the conjugal dwelling. He have engaged in a sexual intercourse under scandalous circumstances, or even maintained the uh, the concubine in the family home. No, yan. Adultery can only be filed by the husband. Tanong, pwede ba siyang i-file ng anak, ng children, nung husband and wife? Answer, class, no. Adultery and concubinage are private crimes. They can only be filed by the private offended party. In an adultery case, it is the husband who can file a complaint. Pwede ba yung magulang ng husband? No. Pwede ba yung kapatid ng husband? No. Only the husband in a crime of adultery. In concubinage, only the wife can file the criminal complaint. Not even their children, not even the mother, the parent of the wife, not even the siblings of the wife, because it is a private crime. No? Okay. Now, other than adultery and concubinage, what are private crimes? Number 2, seduction, abduction, and acts of lasciviousness. Ito, class, these are also private crimes. Seduction, abduction, and acts of lasciviousness. And number 3, criminal actions for defamation imputing the above-mentioned offenses. This is in accordance with Section 5 of Rule 110. So, libel or defamation imputing 1 and 2, meaning adultery and concubinage, seduction, abduction, and acts of lasciviousness. Class, memorize these crimes. No? Adultery, concubinage, seduction, abduction, acts of lasciviousness, and criminal actions for defamation, imputing the above-mentioned offenses. Memorize and memorize. Okay. So, ayan. Let us go further to Section 5. Now, for example, magpo-file ka ng adultery or concubinage, there are parameters provided for by the rules on criminal procedure. Now, number 1, only the offended spouse may file a complaint for adultery or concubinage. No? Only the offended spouse. Now, second, the offended spouse cannot institute a criminal action for adultery without including the guilty parties if both are alive, or if the offended party has consented to the offense or pardoned the offense. If the complainant has already been divorced, he can no longer file the complaint. That is the case of Pilapil versus Somera, because this is considered as lack of status. Now, class, if a spouse will decide to file a complaint for adultery or concubinage, kailangan both guilty parties must be indicted. Dapat pareho sila. Actually, yan ang nagiging predicaments ng mga complainant sa adultery or concubinage. Minsan, you do not want to institute a criminal action against your own spouse because you are trying to save the marriage, so to speak. Diba? You do not want to see your spouse behind bars. Diba? You only want to prosecute the paramour. But the rules of court requires that if the offended spouse will institute a criminal action for adultery, both guilty parties must be indicted. A criminal complaint can only be filed if both of them can be made as respondents or accused. Pag hindi mo isinama yung isa at ang idedemanda mo lang yung isa, it will violate Section 5, Rule 110, and therefore, to my belief, it will lead to the dismissal of your complaint. Now, class, for example, dinemanda mo yung spouse mo and then the paramour. But, after filing the complaint, nagsama ulit kayo sa isang bahay. May nangyari sa inyo, for example. Ang tawag natin dyan, class, pardon. No, pardon. When you say pardon, you have remitted the sins of your spouse. Pinatawad mo na siya. No? A sexual act is considered by jurisprudence as an act of pardon from the offended spouse to the offender or the guilty spouse. No? So, a complaint for adultery or concubinage cannot be filed if there is pardon on the part of the offended party to the guilty spouse. Or if the offended party has consented to the offense. For example, class, this usually happens doon sa mga matagal nang hiwalay, 10 taon nang hiwalay, kanya-kanya na ng buhay, wala nang pakialaman. Sasabihin nung lalaki, diyan ka na, may sarili ka ng buhay, dito na rin ako, wala tayong pakialaman. Sasabihin ng babae, bahala ka na sa buhay mo. Basta kailangan maging masaya din ako sa buhay ko. You know, these are the usual conversations, no? Wala na tayong pakialaman. Gusto mo, magpirmahan pa tayo sa barangay, etc. Now, ang tawag natin dyan, consent. No? You give your consent to your spouse that he can engage in whatever acts or relationships he or she may have. That is consent. Pag nagbigay ka ng consent of that nature, as long as it is your intention to give consent is very much clear and it can be proven in court, then the criminal complaint for adultery and concubinage may likewise be dismissed. Kasi may consent. Pinayagan mo siya. Ikaw ang nagsabi sa kanya na pwede na siyang mamuhay ng malaya. Ang tawag dyan, consent. Okay? If not consent, then pardon. This will extinguish the criminal offense. Okay. Now, who are the persons who can file a complaint for seduction, abduction, or acts of lasciviousness? It can be the offended party. It can be the parents of the offended party. It can be the grandparents of the offended party. It can be the guardian of the offended party. So yan for seduction, abduction, or acts of lasciviousness. But then again, class, in case of adultery or concubinage, only the offended spouse and not his parents, not his grandparents, or his guardian. Okay? Note, such crimes cannot be prosecuted if the offender has been expressly pardoned by any of the above-mentioned parties. Pag nagkaroon ng pardon, class, ma-extinguish din ang criminal liability. Okay? Now, instances when the state may initiate the action for seduction, abduction, and acts of lasciviousness in behalf of the offended party. One, when the offended party dies or become incapacitated before a complaint is filed. For example, nasiraan ng bait yung victim because of seduction, because of abduction, or because of acts of lasciviousness. He was killed or he died. The state can file it on his behalf. Second, if the offended party has no known parents, grandparents, or guardian, no? Because this is pursuant to the doctrine of parens patriae, the state acts as the parents of its citizens. Okay. Now, who are the persons who can file a complaint on cases of unlawful acts under RA 7610? When you say RA 7610, class, you learn this in your criminal law. That is child abuse. Now, sino pwede mag-file ng child abuse? The offended party, the minor, his or her parents or guardians, ascendant, collateral, relative within the third degree of consanguinity, officer, social worker, or representative of a licensed child caring institution, officer or social worker of the DSWD, the barangay chairman, or at least 3 concerned responsible citizens where the violation occurred. So that is for violation of 7610. Again, that is child abuse. Now, filing a complaint by a minor for seduction, abduction, or acts of lasciviousness. As a general rule, the offended party, even a minor, has the right to institute the prosecution of such offenses independently of his parents, grandparents, and guardian. The minor himself, class, pwede siyang magsampa ng reklamo. Exceptions if the minor is incompetent or incapable of doing so. A note, if the minor fails to file a complaint, his parents, grandparents, or guardian may file it. The right granted to the latter shall be exclusive and successive in the order. Ibig sabihin, class, pag hindi na-file ng minor yung parents niya, kung ayaw or reluctant yung or unable to file yung parents, yung grandparents, or guardian, may order yan. Parents, grandparents, or guardian. The guardian cannot institute the complaint if the parent is willing and able to institute the complaint. Okay? The list is exclusive and successive in order. Okay? The pardon to be effective as to prevent prosecution of the accused must be given by both parents and the offended party. That is in the case of United States versus Luna. Okay? So yung pardon for seduction, abduction, or acts of lasciviousness must be given by both parents and the offended party. No, hindi lang pwedeng both parents lang. It must also be given by the offended party. Okay. Now, what are the distinctions between pardon and consent? When you say pardon, it refers to a past act. Nangyari na, pinatawad mo. Consent refers to future acts. It will still, or it is yet to happen. Now, pardon, in order to absolve the accused from liability, it must be extended to both offenders. No? For example, ang pinatawad mo lang yung spouse mo and not the paramour, it will not be sufficient, no, to absolve the accused from liability. Consent, in order to absolve the accused from liability, it is sufficient, even if granted only to the offending spouse. Those are the differences between pardon versus consent. Now, who can give pardon? In concubinage and adultery, only the offended spouse, not otherwise incapacitated. In seduction, abduction, and acts of lasciviousness, the offended minor, if with sufficient discretion, can validly pardon the accused by herself. If she has no parents or where the accused is her own father and her mother is dead. Seduction, abduction, and acts of lasciviousness. Number 2, parties who can give pardon, the parents, grandparents, and or guardian of the offended minor in that order. Extended a valid pardon in said crimes without conformity of the offended party or even if the latter is a minor. If the offended woman is of legal age and not otherwise incapacitated, only she can extend a valid pardon. So pagka ang offended party or ang victim is of legal age already, only her or only she can pardon the accused. No? Now, the pardon shall be given before filing of the criminal complaint in court. Pardon effected after the filing of the complaint in court does not prohibit the continuance of the prosecution of the offense. Take note that pardon must be given when? Before filing of the complaint. Because if pardon is given after the filing of the complaint, it will not prohibit continuation of the prosecution of the offense. Now, class, minsan nangyayari ito sa mga probinsya, di ba? Yung merong tinatawag na, halimbawa, nagkaroon ng hindi magandang pangyayari, ipapakasal na. Di ba? Ipapakasal na ng mga nakakatanda. Kailangan pakasalan mo yan. Yan, sasabihin ng tatay, di ba? Now, ano ang effect? What is the effect of subsequent marriage of the accused and the offended party? As a general rule, the subsequent marriage between the party and the accused, even after the filing of the complaint, will extinguish criminal liability of the latter, together with that of the co-principal, accomplices, and accessories. That means, class, that if the offender and the offended party will be subsequently married, that will erase the criminal liability. And there are exceptions. Number 1, when the marriage was declared invalid or contracted in bad faith in order to escape criminal liability, then it will not extinguish criminal liability. Number 2, in private libel or libelous imputation of the commission of the crimes of concubinage, adultery, seduction, abduction, rape, acts of lasciviousness, and in slander by deed. And in multiple rape insofar as the other accused in the other acts of rape committed by them are concerned. Okay. Now, it does not bar the people from prosecuting the criminal action, but it operates as a waiver of the right to pursue civil indemnity. No? So ito class, ano ang effect ng desistance of the offended party in private crimes? For example, ano ba yung desistance class? When you say desistance or desist, the accused is now withdrawing from the case. The accused now is not interested anymore in prosecution or prosecuting the accused. Nagde-desist na siya. Ina-atras niya na ang habla o demanda. No? Now, what is the effect of desistance by the offended party in private crimes? Does it bar prosecution of criminal action? Answer, no. No? It only operates as a waiver of the right to pursue civil indemnity or damages, but it will not bar the state from prosecuting the accused despite the stance of the private offended party. No? Okay. Now class, nangyayari yan, no? Minsan, during the pendency of the case, dahil matagal, 1 taon, 2 taon, o minsan 10 taon, no? Inaabutan na ng kamatayan ang akusado. Now, what is the effect of the death of the offended party to a criminal action? Assuming that the accused dies, what is the effect to the criminal action? Now, if prior to the filing of a case in court, a complaint was already filed by the offended party with the prosecutor, the death of the complainant will not be sufficient justification for the dismissal of the information. Okay? Ibig sabihin, bago mo i-file ang complaint sa court, final mo sa prosecutor, namatay ang akusado or ang respondent, hindi yan ground for dismissal of the information. Now, during the pendency of the case, the death of the complainant will not extinguish the criminal liability of the accused, whether total or partial. Pag ang namatay class yung private complainant, as long as you can establish the elements of the crime, it will not extinguish the liability of the accused. No? It is the death of the accused prior to conviction which will extinguish his liability, not the death of the private complainant. Okay? Okay. Control of the prosecution. Now, class, sino ba ang nagko-control? Who has control over prosecution of criminal actions? As a general rule, the public prosecutor shall prosecute, direct, and control all criminal actions commenced by a complaint or information. Now, exception to this is when a private prosecutor, meaning a private lawyer, no, may prosecute the case provided that the prosecutor has a heavy work schedule or there is lack of public prosecutors. Usually, class, may mga families, mga victims or families na gusto ng private lawyer. Gusto nila pribadong abogado ang hawak sa kanila. So pagka ganoon, class, inaalaw yan ng court as long as there is conformity or approval by the public prosecutor. Now, if a private prosecutor will actively prosecute the case, the private prosecutor is only acting under the direct control and supervision of the public prosecutor because prosecution of crimes is only given to the public prosecutors or the fiscals and not the private counsel. Third, the private prosecutor must be authorized in writing by the Chief Prosecution Office or the Regional State Prosecution, and such will be subject to court's approval. The court needs to, or the families must obtain leave of court or approval of the court. Okay? Now, prescription of the authority of the private prosecutor. The authority of the private prosecutor shall continue until the end of the trial unless the authority is revoked or withdrawn. Now, what are the matters within the control and supervision of the prosecutor? 1. What charge or charges to file? 2. Whom to prosecute? 3. The manner of prosecution. And 4th, the right to withdraw information before arraignment, even without notice and hearing. No? Once a complaint or information is filed in court, any disposition of the case as its dismissal or conviction or acquittal of the accused rests in the sound discretion of the court. So now, class, for example, the prosecutor will file a criminal information in court. Question, can the prosecutor withdraw the indictment? Can the prosecutor withdraw the information? Answer, the prosecutor has the right to withdraw information before arraignment, even without notice and hearing. So before arraignment, the prosecutor can withdraw the information. Now, once the information is filed in court, only the court will have jurisdiction or will have the say. Only the court can call the shots as to whether this case can be dismissed, withdrawn, or not. No? Yun ang ibig sabihin niyan. The dismissal, conviction, or acquittal of the accused rests in the sound discretion of the court. Okay. The prosecutor can also suspend arraignment. He can also investigate. He can also prosecute. No? Prosecution by the fiscal, dismissal of the case, and downgrading of the offense or dropping of the accused even before plea. Okay. Okay. So I think we can stop here, no? So that you can still go back to your notes. And we will see again next meeting. And we will start from here, sufficiency of complaint or information. Thank you for listening, and I'll see you on the next video.